why would somebody want to register under any of those acts, and how does one proceed?
There is no concept of collecting any maintenance per se under the Act.
What exactly does the deed of declaration do? What is it for?
You cannot register an apartment association under Karnataka Society Registration Act.
Hi Sneha.
Hi, good morning.
Welcome. We today are going to talk about predominantly with Resident Welfare Association and laws related to that. If you have any questions that you would like answered, please put it in the comment section and we will also come back and answer those questions. There has been a lot of discussion about the various acts that are currently present in Karnataka regarding the Residents Welfare Association. Do you want to take our audience through some of these laws that are present? What are the pros and cons, if you can call them that, and why would somebody want to register under any of those acts, and how does one proceed?
Right. So I think I will start off by telling the audience what they should not be doing. As of today, registration under Karnataka Society Registration Act, which is popularly called the 1960 Act, you cannot register associations under that. In fact, the law never provided registration of associations under the Karnataka Society Registration Act, because the objectives of the Act was never designed for an apartment association at all. There is no concept of collecting any maintenance per se under the Act. But I think because of the ease of the process of registration, for many years, a lot of associations registered their association under the Karnataka Society Registration Act, which of late the courts have come down upon and made it very clear, saying that you cannot register an apartment association under Karnataka Society Registration Act, because the objects of the Act is for some other purpose altogether. You cannot collect maintenance under this Act. So any association that is registered under the Karnataka Society Registration Act technically or rather legally cannot collect maintenance. And the purpose of registering an association or an apartment association is to collect maintenance and to maintain common areas.
One of the things is to collect maintenance, etc. That it
Right.
is a large part of it. What happens to those associations that have used this particular act to register?
Ideally, they should today consider registering their association under other acts that are available, which I will shortly talk upon. So they have to, in future, sort of move or transition to these new acts, or rather the acts that existed for a very long time. I feel like that's the only way. There's no other option.
We've had a scenario, actually one of our clients, we won't take the name, where one set of residents have registered under the Societies Act. The other set of residents say, no, this is not the right thing to do. We want to register under the Apartment Associations Ownership Act. And that's what they've done. And they have approached us to do a RWA photo audit. That is the Resident Welfare Association Handover Takeover Audit. What happens in this scenario? I know we're not asking you for legal advice, but what is the way forward for a situation like this? Because then you have two different parties within a society who are not only fighting amongst themselves, but legally also, what are the ramifications?
Right. So if you are registered under the Karnataka Society Registration Act, and if you're trying to collect maintenance, a resident today can say, I'm not going to pay. There's nothing you can do about it.
Okay.
You can't go file a case. You can't go to the registrar and say, I need to collect. So there is no way for you in law to claim that maintenance amount. So then the purpose of forming this, you may have an association, but if you're unable to enforce the fact of payment of maintenance, then I don't see what is the purpose of that registration being there.
Okay.
So I'm not sure about the situation that you spoke about, but in a scenario like that, if an association has registered under the Society Registration Act, they can't do anything about it. People who don't want to pay can opt not to pay. But how do you come together at the end of the day to collectively form an association?
Exactly. So this is the same thing that we were discussing with them. say there are 100 residents and they say, no, you formed under both these acts, I will choose to say that you're under the Cooperative Societies Act and I will not pay maintenance. Right? That is a kind of a stickish, I don't know, probably the law, the courts will have to decide on that.
So now let me talk about the other legislations that are there under which you can actually form an association. Maybe then there'll be a bit
There will
of
be more clarity.
Yeah.
Okay.
So there are associations, resident welfare associations that can be formed under the Karnataka Cooperative Societies Act, which is a 1959 Act. Even though fundamentally, if you read the Act, nowhere does it say you can register an apartment association per se, but the Act allows you to register for any purpose wherein maintenance can be collected.
This is the
Karnataka Cooperative Societies Act 1959.
The previous one was?
Karnataka Society Registration Act 1960,
Okay.
which
So the
today is not
59 one
recognized.
is
59
possible?
is possible.
60 is not.
60 is not.
Yeah.
So that can still be done. Now, why do a lot of people not opt for registering associations under Cooperative Societies Act? Extremely time consuming.
Okay.
Cooperative Societies Act has not been in great demand with respect to apartment associations because they're very time consuming. Lot of procedures. So that is why it's
procedurally
avoided.
it's very heavy.
It's heavy.
Okay.
And also time consuming. That's why people avoid it. But I think as we start using and registering under the Cooperative Societies Act, things may start easing out because I feel like the department is also learning. They've not faced these kind of volumes. So now with so many apartments coming up and people opting to form associations under Cooperative Societies Act, it should start getting easy is my personal view, but may not be the case either. Then the other act where people are registering association is the Karnataka Apartment Ownership Act 1972. It's been there since 1972. But primarily people have not again opted, a lot of apartments have not opted to register under the 72 Act because there is a bit of ambiguity in the Act. There is, so the way acts are perceived is to see who do I register it before.
Okay.
Now, if you look at the Cooperative Societies Act and the Society Registration Act, there are authorities before whom you go and register. Under the Societies Registration Act, there is the Registrar of Society. Under the Cooperative Societies Act, you have the Registrar of Cooperative Societies. Now, under the Karnataka Apartment Ownership Act, the competent authority has been nominated to be the Cooperative Society, Registrar of Cooperative Society. But as such, he says, I'm not empowered, or there are no rules that there are no rules formed saying these are my rights, so these are my obligations, and this is what I'm supposed to do in the Act. So he says, I may have been named,
but I don't have the
but
authority.
I don't have the authority or the power to do anything. So this sort of left everybody in a bit of confusion, saying then how do I do it? If I don't have an authority, is this act even legal? And unfortunately, the Karnataka Apartment Ownership Act does not consider the association to be a juristic person like the Societies Act and the Cooperative Societies Act. What does that mean? If you're a juristic person, by law, you have a right to sue and right to be sued.
Okay.
Just like companies. Companies have a right to sue because they're juristic persons under law. If you are an association registered under the Cooperative Societies Act or the Society Registration Act, you're a juristic person. So you have a right to sue and right to be sued. The Act allows you to be a juristic person by stating it in the Act. But the Karnataka Apartment Ownership Act does not recognize associations registered under it to be a juristic person.
So it doesn't specifically state that it can be or cannot be
If it
sued.
doesn't specifically state, it is not.
Okay.
That's the presumption we have to draw.
Okay.
So that is one of the reasons why not many people have gone into the KAOA 1972. Now, this is not a blocker, but I'm just stating, my view in terms of why people have not opted for these laws despite them being there. So lack of clarity is a very big issue. But there were still many developers who registered an association under KAOA. Another problem it's not a problem, but another issue with KAOA is that every apartment owner has to be a signatory to the deed of declaration. So let's see.
It should be 100%.
100%. So if there are 1,000 apartments, 1,000 signatures have to be there in the DOD.
Okay. If it is not?
If it is not, you can't register. Even if you registered an association without all owners agreeing to it, then it's not legal. under the Act.
So okay. So you're saying that if there is a society with 1,000, 2,000, 3,000 units, and they decide to register under the KAOA 1972 Act, then the deed of declaration has to be signed by every single owner of those 1,000 units or 2,000 units.
Correct.
Okay.
So how are builders dealing with this? Before selling the apartment, when the ownership is with the landowners and the developer, at that point they prepare a DOD.
Okay.
So then you're eliminating this whole problem because it is at the time of execution of the DOD who is the owner.
So
that's what
just
determines.
you get two signatories.
So they are the owners. So at that point they register the DOD. So the problem of this whole, requiring 1,000, 2,000 signatures is solved.
Okay. If somebody does question that later on, saying that no, I have bought this from the builder, but I don't agree to this, then they have no recourse to it.
No. So the Act says that apartments, it's transferable, heritable, etc. So every time a new owner comes in, the owner doesn't have an option because it's already been submitted.
Okay.
Your apartment is already submitted to the Karnataka Apartment Ownership Act. So again, if you have to withdraw, everybody have to come together to withdraw. One person per se cannot come and withdraw. That's how the Act is structured.
Okay. Got it.
So that's one of the reasons why builders register a deed of declaration, so that you can avoid this whole every single owner has to come forward and sign.
What exactly does the deed of declaration do? What is it for? If you can just give us a brief idea, and then we can go to the next.
It's a document where you're coming together and saying that this is my apartment. Let's say your apartment is constructed over 5 acres. You're saying this 5 acres of land I'm submitting to the Karnataka Apartment Ownership Act to be, so that this 5 acres is governed, or I can use all the rights and obligations that the Act has, given me. I will use that, and I'm submitting this property of mine. I'm talking about collective, not individual, where everyone's coming together and saying we are submitting our entire property to this Act in order to be governed under this Act.
So
it's a choice.
So the deed of declaration is a choice, but only under the KAOA.
Correct.
Okay.
So you make a choice whether you want to be governed under this Act or not.
Okay.
That's how the Act is designed. You have to choose.
So
You can choose. You can not choose saying that I don't want to be governed under this Act. There are other acts that I want to be governed under.
You spoke of 3 different ones. So 2 of them can be utilized for the
Resident Welfare Association,
Correct.
which is Co-operative Society, Karnataka Apartment
ownership.
Ownership Act. I also understand, I just want to bring this to the notice of the audience. I also understand that there's a lot of debate going on today that there's a PIL that's filed before the Karnataka High Court as to the KOA is not the right act and, etc. So everything that I'm saying is as the way it stands today. Now, there could be changes in the future.
Correct.
Nobody knows.
Yes.
My only advice to the audience is that please don't read news articles and get perturbed. Wait for the legislation to come out, or wait for the court judgment to come out.
So you're saying that until the judgment comes, we can still follow what is an
The
act
current
and
law.
current law and an act today. So we don't need to worry about what happens tomorrow.
Correct.
Even if something is passed as an act tomorrow, it should take care of whatever is happening today.
Absolutely.
So there should not be an upheaval of things.
Correct. Because as of today, there are Karnataka High Court judgments which says you can form association under Karnataka Apartment Ownership Act. So while the judiciary is also giving direction in that fashion, there is no need for you to get scared saying this is not the right act. It may not be. We don't know. But I think we should all wait it out, because even if the legislature is going to come in and design something new or a fresh altogether, it is going to take care of associations that have already been registered under various acts. Why are associations that are registered under cooperative societies are going to suffer? Because the act in the first place never allowed you to register an apartment association under the act. So therefore, people who are registered under Karnataka Society Registration Act have to figure out how to transition. But those that have been registered under other acts, I don't think there is a need to worry or get disturbed, because as of today, it's legal.
Got it. Now that we've got the umbrella.
I'm sorry, one more thing that I want to mention is you can also register resident welfare associations as a Section 8 company, a non-profit organization. can also register under the Partnership Act. So these are also options, but they're not highly experimented because there are too many share issue, ratios issue. How do we do it? How do we structure it? And compliance is thereafter. So it's not extremely conducive. It's like
So it's like running a small company. At the end of the day, it's an LLP or a private limited company you need to run. Okay, understood. Now we've had the umbrella. We have an idea of the various acts that allow you to run your society to the way you like. As you said, it's an opt-in. You do have management committee members who take the responsibility for running these. What are the legal ramifications, if I can call that, or what are the fiduciary responsibilities of these office bearers?
right. So the office bearers are governed by the bylaws. So
Okay.
every association, no matter which act you're registered under, have these set of bylaws, which are your rules in terms of how to operate and run. These rules and regulations have to be in consonance with the act that you're registered under.
Okay.
So your responsibilities and your obligations and all of that is coming out of these bylaws.
Okay.
So it's how you structure it.
The reason for this question is, I'm sure you've heard of recently, there was an unfortunate incident in one of the societies where a young girl, due to reasons, passed away. Now, the president of that society was then taken to jail. A lot of the people now are unwilling to take these positions. So what would you have to say to those people? Because is that something that they need to be worried about, or can something be done so that they don't need to be scared that any misstep will land them in jail?
So the way I look at it is that why do you form an association? Because you want to take care of the property. You don't want the property value to depreciate. People who are living in that community want to benefit out of the facilities that that property has to offer, right? Now, anybody who's coming into the governing committee, this is your primary objective. That I want to maintain a property which is beneficial for everybody, including myself, and we keep it in such a way that there is always appreciation for the apartments here.
Correct.
That's the objective. Now, if this is not your objective, then you shouldn't be stepping into the governing committee.
Okay.
Now, in the example that you took, I'm not sure, but I don't know what's gone wrong there, but without commenting on the facts in that case, it is the primary responsibility of the office bearers who come in to maintain the property.
Correct.
So you can't escape that. You can't say, I will not maintain the property at the same time not face liability. That's not how it works.
Okay.
If you are going into a responsible role, it's like company, right? Where let's say if I get appointed as the CEO of the company, I have to run the company. If I'm failing at it, then I have to step down. So it's very similar. Now, of course, when you're part of the governing committee, you have these responsibilities. So anything that goes wrong with respect to the common areas, it is your responsibility. So you ought to take care. Now, if something that is not within your control takes place, then there is always a rule which says that, I am covered being an office bearer.
Okay.
Because I'm an office bearer, I am, it's like it's like indemnity. I'm indemnified because of my role as an office bearer to the extent that this issue that happened
Was beyond my control.
was beyond my control.
Got it. What are the financial responsibilities? What are the other responsibilities that they need to be aware of? What are the various things that, you have various roles. You have the
Right.
president, you have the secretary, you have the accounting
Treasurer.
person, the treasurer, etc. So what are their roles? Because I'm sure somebody who takes a position should understand what their responsibilities
Correct.
are and what is the consequence of somebody not performing their roles. You already talked about if they're there and they need to take care of advancement of the whole society. If that fails, then you are liable to be prosecuted.
Right.
So
in terms of finance, of course, there are treasurers. So the designations that we're carving out, like president, secretary, treasurer, these are all arising out of the bylaws. So if your bylaws provide for these designations, great, you can have it. If the bylaws don't provide for designation, you can still have the designation by passing regular board resolutions, by nominating people. That is doable. Even if your bylaws don't provide for certain things, you can do it with respect to
So it seems
board
that the
resolutions.
bylaws seem to be an
Very
important part.
Very important.
So when the bylaws are being formulated, it's important that they talk to somebody who understands what they're doing and go through the bylaws.
Right.
So when are the bylaws formulated? Is it at the same time when the DOD is formulated? Do the residents who come and join later have an opportunity to reframe the bylaws?
Right. So yes, to answer your question, bylaws get formulated at the time when the DOD is registered, because bylaw is an important annexure to the DOD.
Okay.
So in most associations that are registered under Karnataka, apartment or any association which is registered by the developer, the bylaws is coming from the developer or the builder.
So this is not standard then?
From the builder's point of view, it's standard, because they will circulate a standard bylaw. It's not custom made to such a large extent. They'll give you a working bylaw.
Okay.
We've seen in our own, we have a lot of clients who are apartment associations. So when we deal with them, we've seen that a lot of conflicting rules in the bylaws itself.
Okay.
So 95% of the cases, when you start or when you're in the process of handover, you will observe that there's already an association that is registered under any one of these acts, and you're also getting the bylaws.
Okay.
So my advice to people who already get these bylaws is, please work around this to understand where are the issues. Once issues are identified, try to amend your bylaws. In my experience, what I've seen is that in order to amend bylaws, a lot of bylaws have this rule that you need 2/3 majority, not just majority, present and majority. So the question that is most asked for is, where do I get this 2/3? You have to get it. If you don't get it, then you'll have to approach courts. So there's a way to work around it, but this would be the right way. That see what the conflicting issues in the bylaws
When
is.
you say 2/3, it's 2/3 of owners. If the apartment is not yet sold completely,
then the apartment belongs to someone, right? It probably belongs to the landowner.
Okay, that's an interesting point. So there's something just occurred to me. Say a builder has got land from a landowner, and they have built 100 units.
Right.
The 100 units currently are under whose name? They're under the name of the landowner and under the name of the builder.
Right.
Right? So they themselves form 50% of the each or whatever the portions of ownership.
So I can explain the process.
Yeah.
Generally what happens is, if a landowner has 5 acres, he can construct the apartment complex himself. If he does not want to, and if he wants to do it as a joint development with a developer, he gets into a joint development agreement.
Correct.
Wherein commercially they will agree what is the ratio of land and building that sort of goes to the developer and the landowner retains. It could be a 70-30, it could be a 60-40, it could be a 50-50, any ratio that's commercially agreed between the two parties. And that joint development agreement gives rights to the developer.
Got it. And we spoke of this last time also, yes.
Now, after this, generally, the parties get into a supplemental agreement or a sharing agreement. The reason this agreement is entered into at a later point is because at the time of JDA, sometimes you don't have the numbers in place.
Correct.
But once the building starts getting constructed, once a sanction plan is in order or in place, then they get into a sharing agreement because they know how many apartments are being built.
Correct.
And let's take the scenario that you presented where you're saying 100 apartments, right? Let's say 50 to the landowner, 50 to the developer. The number of apartments and which block goes to whom is part of the sharing agreement.
Correct.
So based on the sharing agreement, you will know how many apartments are sold, and whatever apartments is left, you will know whose share it is.
So you have to get then signatures from the landowner and from the builder and the other owners who've bought properties to get a 2/3 majority to change.
Absolutely. They are like any other. If the
Yes.
builder, let's say today, retains 15 apartments in an apartment complex, the builder is the owner of those 15 apartments.
Got it.
And they are part of your
Perfect.
RWA and governing and all of that.
Correct. Can the builder hold, if the builder is staying and owns property there, can they have positions of power in the RWA?
Absolutely.
Is that not a conflict of interest?
So it is not a conflict of interest because they have sold most of their apartments. And now, how do you call it conflict of interest? I don't see the conflict here because I've constructed.
You have
It has nothing to do with governing council.
Okay, now I have 100 units, I retain 10 units. So I get more votes than anybody else, and I am the president of the society. So don't I have then lot
So
more
it is
power?
a situation where, let's say, if there is somebody who intends on buying 20 apartments in a complex of 100 apartments, it's a similar situation, right?
Okay.
If I, let's say, buy 20 apartments, that means, I'm dominating in terms of my votes. But if your bylaw says one vote per flat, then that's how it is.
Okay. Now that we've established under which act a society can be formed and the various responsibilities everybody has, one of the things that a society needs to do for running is to collect maintenance. Now, maintenance is collected based on different calculations and different formulas. There have been cases where people have either refused to pay maintenance or people just don't pay maintenance because of various reasons. What is the legal recourse for a society or the management committee if this happens?
Right. So yes, this is a common problem. That's something that I've also observed. The way I look at it is, if you're unable to recover the amount within 6 months to a year, then you don't have a choice but to go to the court of law.
When you say recover the amount, what do you mean?
So you give notices. A lot of bylaws, in my observation, have a penalty clause. So you send notice, you send your monthly invoices, then you also send your penalty notice, all of that. And despite that, if the owner is not paying, of course, the best way to see is how can I resolve this in my general body meeting, if that's permissible. If nothing is working, then you don't have an option but to file a case of recovery before the court of law to recover this amount.
What we have seen in certain situations are like this. You have a resident who's saying, I have complained about X, Y, and Z that the society needs to take care of so that it solves my problem. The society, the management committee has turned a blind eye to my request, and the reason for the society management committee there is to take care of me. They have not done it, so I refuse to pay.
Right. This is like a threat, saying if you don't do what I want you to do, then I will not pay you. That doesn't generally work, or legally it's incorrect to, if, let's say, as a resident, you want your management committee to make certain changes, then there is a way to approach. The approach can't be, I will not pay you, I'm going to withhold because I'm not getting what I want. That's not how it works, because it's not about you, a single flat owner, but it's always a collective.
Say there is, a burst pipe that is in the common area in a shaft that is causing problems to the resident.
Right.
And they have repaired it, but it continuously leaks and it is flooding his bedroom or toilet or whatever. And the resident has complained to the management committee saying that you need to take care of this because I can't take care of it. And the management committee has not addressed it. Even after repeatedly telling the management committee, then what is the recourse?
So there are two issues here.
Okay.
Residents have to be very aware to not mix the issues that they are facing with maintenance.
Okay.
Because let's be honest, why is maintenance being collected? Because the association is spending X amount of money.
Okay.
It's not that the association is not spending money but collecting money from you. If that is a scenario, then we look at a different legal option. But generally, associations are collecting money because that amount is going out of the association funds, which means you have to pool into those funds.
Got it.
So that's a separate issue. Now, the scenario that you just mentioned is a situation where I, as an apartment owner, is facing an issue. I'm complaining to the management, they're not doing anything. I can claim damages in a situation like this.
Okay.
But I should not be mixing this with the maintenance. Because like I said, maintenance is an amount that the association is spending and you ought to put your money into that pool. You can't say, no, the basketball court is not functioning properly, therefore I'm not paying you maintenance. That's not how it works.
So you claim for damages that you are facing. So you have maintenance corpus, and there is also something called a sinking fund.
Right.
What is the sinking fund? Why is it needed?
So sinking fund is something, in my view, it's contractual in nature.
Okay.
Because a lot of agreement to sell mentions, and in your consideration that you pay for apartments, there is a corpus amount that the builder is collecting. And in these clauses, you will see that the sinking fund is being collected for X purpose and the balance will be handed over to the association. Now, this is a great clause because this comforts a lot of new associations that are coming in. Because they have a corpus that they can bank on without thinking about where do I start. I don't have a corpus. Tomorrow, if there's an emergency that happens, and how do we bring in that spend, right?
Got it.
So it's a financial security.
So that means that once a society is formed and the society takes over, which we'll talk about next, the sinking fund also needs to be transferred to this society.
Yes, contractually, that's how it's designed. The
Okay.
purpose of a sinking fund is a corpus amount that the builder has collected, which they will then hand over to the association when the association of residents takes over, so that they have financial comfort in terms of how to move ahead
Got it.
with their functioning. Now, what is the issue that we see? That a lot of builders deduct some amount from the corpus fund, saying that, and also it's not just for the comfort of the association, it's the comfort of the builder. Sometimes the builder faces difficulty if he's, so generally most builders say, I'll give you 1 year of free service, so 2 years of free service. It's technically not free, it's collected in some manner. But let's say if the builder, because of failure to hand over on time or due to some other issue of not being able to hand over after this 1 or 2 year period, if they have to continue running, they will
They'll
also bank on this corpus
Sinking
fund,
yeah.
right? And those are deducted and then handed over to the association. So it's beneficial for both. But of late, I've also been seeing that a lot of builders are not collecting this at all. They're like, I don't want to deal with this issue of
So it's more of a
collecting.
headache than anything.
So a lot of people are choosing not to do it. So it's purely contractual in that sense of how they want to hand over. But you can't collect sinking fund contractually also avoid paying this amount, because you will have to showcase either how you spent it, what was the purpose you collected it for. So yes, if you want to legally recover this amount, depending on how your contractual clause is constructed,
You can take a look
you
at
can
it.
always.
So we've talked about a lot of different topics, and one of the most important things is after the society is formed, there comes a point when the society takes over from the builder because they need to take ownership. At this juncture, there are a lot of legal tests or legal checks that need to be done from the buyer's side so that they are taking over a healthy baby. Do you want to take us through what these are and what one needs to be aware of?
Right. So in law, there is no definition of a handover takeover process as such. But this is like a company being acquired,
Okay.
or where an investor is investing into the company and they want to do a complete due diligence. It's a very similar situation. I think awareness, the first thing is at the time of handover takeover, the residents have to be aware of the property. Now, it may not be very prudent for someone to just do a takeover, sign off some documents without being aware of what they're doing. So in my opinion, it would be best in a legal situation, the first thing is to be aware of your documents.
When you see documents?
When I say documents, everything from land to the building plan and the sanctions and all the permissions and everything. So it's exactly like how an audit that you would conduct of a title report or a title search that you would do when you're purchasing a property. A very similar structure has to be adopted by the association to look at the whole building in terms of land, as well as whether the building is built and if all the necessary permissions have been obtained. So first is to be aware of every single document that you are taking over, which will also help you understanding your own land, which is very important. Your own land and building. This understanding for somebody who's taking over is very essential. Number two, be aware of your land as well and your building, which is something that you do, right?
Yes.
What do you have in it? What are the structures that are right? What have gone wrong? These are essential things that you need to know. Even though this is not legal per se, but this education is very important, because this, when you read it with the documents that you have, is a great understanding that you have of your own property. And when this comes in, then comes your financial aspect, wherein if there is a sinking fund, then how are we going to take the transfer? And also understand your bylaws during this process, because now you will start running your associations. And when you start running your association, you need to be aware of what the rules are, which means that does my bylaw allow me to collect monthly maintenance, or is it quarterly, or am I flexible enough to design how I want to collect? Can I collect maintenance in advance, or is it prorated later on, etc.? So how do I call for meetings? This kind of understanding is very essential before you start running your association. So in terms of legal, what we look at is we do a complete check of all your land documents, all your building documents, give you an understanding, a report of your own building, and then tell you what are the documents, original documents of the builders to hand over to you, and what certified copies you need to collect.
Can you name a few examples of what these documents are? You don't have to go through the whole list, but top three.
I think conveyance deeds, like all your previous sales, gift, JDA, sharing agreement. So the whole lot of how the transfer has happened, documents related to transfer of land. And then comes your construction, your permissions, where we look at sanction plan, then we look at your occupancy certificate, then we look at a whole load of permissions given by various authorities in order to construct this building. Necessary sanctions have been obtained. If your lift permissions are in place and STPs are in place, at least you have documents to support all your common areas. That's something that we look at.
I'm sure somebody would ask this question because there's been a case recently where there was a forged occupancy certificate, right?
Right.
We talked about this briefly last time also.
I remember, yeah.
So there is only to a certain extent that this can go through, because as you said, you provided this information and you're going to take it that this is correct or this is true to its nature. What does the recourse that a resident has if tomorrow the occupancy certificate itself is forged?
Right. So, of course, there are legal ways to approach this. One is in a situation of photo that you're talking about. We first do a preliminary check based on photocopy documents. And then, while the handover process is in place, we also check originals. Now, if somebody's forged a document, it may be difficult even for us to understand, or any lawyer for that matter. It's honestly a chance of luck. Like if I'm able to suddenly see, and then it can be disputed. Suppose I say, I think this doesn't look original. Some people could say, no, I think it's original. No, OC cannot be, right? Unless such a scenario comes in, the presumption is that it's original.
It's original, correct.
So in a situation like this, what do? You have legal recourse. If your property is a RERA registered property, then you can take recourse under RERA, or you can go to the police because it's a forged document, it's a crime under law. So there are many legal avenues for you to approach this. Yes, it's difficult. It's a difficult situation. Obviously, when there is a problem, it appears to be difficult. But I feel like there are enough solutions which people need to start exploring. And the one thing that I see in my experience is everybody is very worried that it's time consuming. I may not get results. I don't deny the fact that it's time consuming. Of course, judiciary is really, there is a backlog, and it's not just an issue of the judiciary, it's just how the structure is. It's everybody's responsibility to make things better. So there is an issue in that sense of time consumption, but that doesn't mean you don't take action. Take action, continue with your life, something good will come out of it.
Definitely.
So like I said, just coming back to where I stopped, is we will do a check and we will see whether the documents, originals are being handed over, certified copy, etc. Now, generally after this process is over, there is a sign-off. Either there's a handover agreement or some kind of an understanding where we say that all these documents have been handed over, and some kind of a agreement is signed between the parties so that they can take over. Now, it is essential, or it's important to understand that you may not get 100% of your documents. Some small documents may have been missed, but that you should leave it to your lawyer to decide, is it okay that we move on with the documents that we have, or are there some critical documents that are being missed? So all this is a process that we look at when it comes to handover.
You're talking about
negotiables and non-negotiables.
You're talking about legal documents.
Legal documents.
Even in terms of technical documents, you should leave it up to the technical auditor to tell you whether they can go ahead or not. Yes. Okay.
So this is how we close our handover process. We look at the documents, we look at the originals, we sign off with an agreement. So the process is a good 3 to 6 months, depending on the size of the apartment.
So you mentioned negotiable and non-negotiable. So you're looking at the priority and the severity of the document's necessity, and then you will say whether it's okay or not.
Yes.
There could be a certain scenario where they can generate a new document and give it, and then you can say, okay, fine, this is fine, then you go ahead. We've talked a lot about the laws, we've talked about what the process is. Let us, towards the end of this conversation, look at a dire situation where the management committee says, okay, we're going to take over this, but the builder, for whatever reason, says, I just don't have the documents, I won't give it to you, or I don't even want to do the handover takeover. Then what happens?
Right. So it's a very rare situation that the builder wants to continue maintaining the association because for him also it's a burden.
Yeah, they may not say that forever, but I want to do it for the next X number of years. Or,
right. So I think the situation that you're looking at is where there is some kind of a difference of opinion or there is a dispute in terms of documents. Then how do you approach it? I would say go ahead and do the takeover because you need to be in control of your association.
Can we do a contingency contract and say, fine, I'm contingent?
If the builder is going to sign such a contract, yes. I'll be very surprised if somebody comes and signs a contingent contract of this nature, saying that you take over and then over this period of time, I will give you these documents. It's a very rare situation. So in a situation like this, when there is a difference or a dispute in terms of not handing over documents, or let's say the builder is not even responding, then what do? My advice would always be take over. Start running your association. It's very important for you to be in control. Don't say I will not take over because documents are not given to me. It has to happen parallel.
The concern is there is a audit that happens. Audit findings come about. There are many points that need to be addressed by the builder.
Correct.
The builder says, no, you need to take over now and then I will look at it. But if I take over now, I have taken over a sickly baby. I have to then pay for the medication for this child. Whereas if I was to say, okay, I'm going to take over contingent on you addressing all of this over this period of time, then there is still some amount of recourse or some amount of leverage that the management committee has with the builder because there is still some skin in the game for the builder.
So that's a situation where the builder agrees to continue maintaining your apartment. The situation that you're talking about.
No, what I'll say is, some of the discussions that we've had will say that we will deem the handover takeover complete, contingent on X, Y, and Z being adhered to and met in this particular time frame, whereas we will take over running the society using our own FMS or an FMS provided by you. We will have our own estate manager. So we have control of the situation, but there are these lacuna that have been identified that needs to be addressed by you because you promised it.
Absolutely. So what you're talking about is a situation where there is communication that is ongoing between the association and the builder.
Yes.
Simultaneously, the association maintaining. That's pretty much my point as well. That you keep the communication going, saying that these issues have not been addressed. But what happens is, let's say there are certain issues which the builder has not addressed. Can you, or how long are you going to sit on that issue? Let's say it's a situation where the STP is not functioning. How long are you going to be in a property where the STP is not functioning until the builder comes in, rectifies the STP? I would say in such a situation, please give a timeline. There should be any contingency should have a timeline saying within this period I need you to resolve it.
Correct.
And if that problem is not resolved, you may have to initially invest your funds, rectify, then claim damages from the builder.
Got it.
That should be the process. I don't think residents or the association should sit on a problem for a long time because ultimately you have to understand that this is your property. Yes, the builder may not have done a proper job. There could be some defects.
This comes back to the original discussion that you had that it will take time, but there is recourse at the end of the day. There is, and you do get a solution. Yes, you will have to run.
You have to act.
Yes.
You can't say, no, I will wait for the builder to come and rectify because that's not going to happen.
Not going to happen, yes. Because it is not in his current interests, but it is in the owner's interest and they need to follow. Fantastic. Well, thank you very much, Sneha. Very lovely talking to you.
Thank you. Thank you for this opportunity.
We will be talking a lot more on a lot of different topics and hope to have a series of discussions with you regarding very interesting topics with regard to law and property, maybe even 15-minute, half-an-hour conversations so that
Certainly.
people are able to get updated on the various things.
Certainly.
Thank you.
Thank you so much.
Thank you.